Did you turn that on, your mic?
Not yet, but I will.
Yeah, yeah. Switch the on switch. Good,
I think
thank
we're
you.
on. Yeah.
Yeah.
Okay. All right. It's a pleasure to be here. Thank you. Being one of the non-technologists, I understand that some of the presentations earlier from one of my legal colleagues were fairly technical, and this one is not going to be so. I do have some PowerPoint slides, but other than that, there's going to be very little technology. I'm going to talk about public policy and sensor networks and use privacy as a bit of a case study because I want to start off talking about some of the broader issues in thinking about public policy and technology. And hopefully I can get this to work. Oh, no, I'm sorry. This is not supposed to be happening. There we go. All right. Hopefully it won't happen on any other slide. Okay. I've spent a fair amount of time. I run something called the Law, Technology, and Public Policy Clinic over at Bolt, which is kind of the lab equivalent of law school. And so I have students who actually try to do what I like to think of as policy implementation. So we think about research and technology transfer. Well, we do legal research and we try to do policy transfer. And so we do, policy application. We work on legislation. We work on regulatory proceedings at the federal level and at the state level. Sometimes we engage in litigation. We do amicus briefs. We also work in standard-setting organizations. We do independent research where we try to look at a given technology and the way in which the direction it's moving, and using current public policy, current consumer expectations, analyze it and say, how is this new technology potentially shaping, altering, threatening, advancing our expectations, our social policy, and how is it that we in the policy arena should be approaching this technology? So, first thing is to kind of think about existing law, right? And it can certainly be a hindrance or it can be a help, right? But existing law doesn't necessarily tell us very much about what people want or what people expect, because often the technology is so new or has altered the way in which we approach something in such fundamental ways that the law all of a sudden just doesn't make any sense at all, or it doesn't appear to apply. It's in the little interstices in the law. And so a perfect example would be the advent of electronic communications, right? We had a wiretap law that was written to prevent government and private parties from eavesdropping on phone communications. However, it was written to prevent the oral acquisition, right? So it had to be by ear, right? And so all of a sudden we had electronic bits of data that were being acquired in another way. Well, was that an interception? Well, sure, people's expectations might be the same, right? We were engaged in a communication, the same kinds of issues of privacy, but the law, in fact, really didn't respond because the way in which it had been written, at the time in which it had been written, we were focused on oral acquisition of information. New law, I think technologists, researchers, the business community often views law as something that is hostile, right, to the advancement of technology. And I think particularly that there's been that perception of privacy laws, right? There's been a lot of talk in the business community about developing their own best practices, about self-regulation, often as an effort to stem more public forms of rulemaking. Whether they be technical standards, but more specifically regulations, U.S. law, or even international policy. And I think that viewing law as hostile is not necessarily the best way to approach it. In many instances, law is actually an enabler. It can help establish parameters, it can establish best practices, it can help create legal certainty. And we've certainly seen instances of that here domestically and internationally. Things like digital signature laws, right? Law, in fact, is something that we need to see change in order to create an environment that is supportive of a new technology. And I think when we're talking about privacy, there's a real positive benefit to viewing law as something that can, in fact, create an enabling environment if it's approached early on in the process. And the final kind of overall comment is the notion, the process is very important. We have technology in a bubble or technology policy, right? And certainly CITRIS is about, I think, technology and policy together. And certainly in the clinic, that's the approach we like to take. Technology as a lawyer, I think some people think lawyers see technology and they want to figure out how they can legislate it. That's not at all the approach we take in the clinic. We like to look at technology in the social context. Privacy is something that is very, very difficult to devoid from a specific context. Whenever I'm asked to come and talk about privacy, it's like, well, privacy, do you want me to talk about reproductive freedom? Do you want me to talk about your medical records, your financial information? It's an extremely contextual concept. And just like security, while security and privacy, I like people to understand that those are not the same thing. A lot of the ways in which we think about security, we think about it as contextual, we think about it as a risk assessment, we think about it as threat analysis, and we think about it as a process, right? We don't take it off the shelf and install it, and now we have security. And privacy is the same way, and all those contextual considerations have to be part of any conversation about privacy. And to do that, I think engaging in a discussion when you're thinking about technology with folks in the legal community, with folks who are in the community that might be affected. So where are you thinking about deploying the technology? What are the expectations, the social expectations of the people in that environment? What are their privacy expectations is very, very important. We've done a little bit of some empirical data collection in some different environments, which I think I'll talk about a little bit later, which are useful in thinking about the way in which context influences privacy and privacy design. Technologists, I think, sometimes when they look at, you have a few options when you're thinking about policy and particularly privacy. You can be kind of agnostic. Well, we're just building the technology, right? Please don't really talk to us about how other people are going to use it. I've spoken with many researchers here on campus and in industry who actually avoid research applications that they think are going to raise privacy concerns. And I think that's really unfortunate because we know that certainly the real-world applications aren't going to avoid privacy concerns. But, of course, if you're a researcher and you don't necessarily feel like you're able to engage with a policy process so that you can figure out how to explore different kinds of applications in a way that's sensible, I can understand that avoidance. Many of you are probably familiar with Walmart's decision to use the little RFID cameras to take snapshots of people when they're taking products off the shelves. Now, I think they had really bad counsel, right? Whoever their public policy people were, they should have said, look, if we're going to do that kind of testing, we have to do it in a way that is open and transparent. And I understand that eventually the deployment is going to be in a way that probably is surreptitious if we want to catch criminals, right? Maybe, but in testing and thinking about the deployment, doing these secret kinds of tests can really create quite a technology backlash, which can be quite detrimental when you're thinking about trying to establish a framework to roll out a technology. You can think about designing a technology to meet policy goals. We think about privacy by design. I was engaged with some other folks on the platform for privacy preferences, P3P, right? There was an effort to think about how do we design a technology that's going to assist with some of the privacy issues. I think the next step is really engaging with the policy process. So not just looking to see how can you use policy to think about your technical design, but to try to think about technology and social goals in a little bit more of a holistic way. And that is what my research is focused on and what we try to do in the clinic with students. So I want to talk a little bit about privacy law because I was asked to talk about privacy. And I'm going to be very US-centric right now because with 20 minutes I didn't have a lot of choice if we want to be too general. Privacy law in the US, right, it's extremely fragmented. It's constitutional, statutory, common law, state, federal. It's also exceedingly sectoral. We don't have kind of general overarching principles that guide all of our private sector or all of our government in how they deal with privacy issues. And what we end up with, unfortunately, we have privacy rules that tend to hinge on, is the information video, or is it voice, or is it electronic, is it in paper? Who's holding it, right? So your medical information in the hands of the pharmacy or in the hands of your doctor or in the hands of your employer or can all be subject to different rules. And sometimes those rules, particularly as we're dealing with convergence, right, where we have different things starting to look the same, right, voice over internet, things like this, we may have inconsistent rules that become really difficult to reconcile. In thinking about sensor networks, some of the more important areas of law in the U.S. To be familiar with, first is the Fourth Amendment. The Fourth Amendment, the Constitution, protects people against unreasonable searches and seizures. Of course, this only protects individuals against the government. What's important about it, I think, for technologists to understand is that the reasonable expectations test, which was established in 1967 in the first decision where the Supreme Court said that privacy protects people, not places, and so if you're making a phone call from a public phone booth, even though you're in a public phone booth, you still have a reasonable expectation of privacy. That test is both a subjective and objective test. So it's both about me as an individual, am I manifesting a subjective expectation of privacy, and then society as a whole, do they objectively think that's a reasonable expectation that they want to honor? Technology has played an incredibly important role in establishing the baseline of what is an objectively reasonable expectation. So if you want to think about copyright policy, right, where we have technologies that have substantial uninfringing uses are fine, right? And so we've seen technology as it advances and enables us to do and interact with information in more ways. We've seen an expansion of the concept of fair use, right? On the other hand, in privacy, as technology has enabled different kinds of monitoring and surveillance, what we've seen is a shrinking of the space in which individuals can have reasonable expectations of privacy. Certainly we can have them outside the home, but the minute something becomes technically possible, right, it tends to no longer be reasonable for you as an individual to think you might have some privacy. Now, there are some outer boundaries on that which the Supreme Court has just begun to set, right? And this one is the scope of use in the Kylo case, which was the thermal imaging case, which people may be familiar with. Basically, the police were aiming an infrared sensing device at a house, and they were trying to figure out how much heat was being emitted. They were basically thought these people were growing marijuana, and they wanted to find out how much heat was being emitted from the walls of the house. And it's an extremely interesting decision. I have I have both law students and computer science students. Most of them are from the School for Information Management in my class. And I have them read the decision, and they're really fascinated by it because the court goes on and on talking about off-the-wall versus through-the-wall sensing, right? So there's this, all of a sudden, there's this big legal distinction about whether or not you can judge what's actually happening in the house, or is it just what's emanating from the house, and is the technology bouncing off the walls, or is it actually going through the walls to judge the heat? It's a very, very, for I think technologists, very, very interesting decision. You say, is the court crazy, right? Drawing these kinds of, but what comes out of it is that they decide that thermal imaging it exceeds the bounds of the Fourth Amendment. It is a search, but the reason is that because it's not in common use. And as a technologist, I think that's a really important concept, right? Because to the extent that sensor nets, right, are in common use, or RFID technology becomes commonly used, then our expectations of privacy, right, end up getting shaped potentially by that technology. So these are important things. The final series of cases I want to talk about, because they're important in thinking about privacy and technology, are what I call the business records cases. In the 1970s, there's a series of cases. The two most important are Smith v. Maryland and U.S. v. Miller. The holdings of the cases, one is about telephone toll records, so trap and trace devices, pen registers, catching the incoming or outgoing phone numbers that people dial. And the Supreme Court basically said that seizing those numbers from the telephone company or getting the telephone company to turn over those numbers was not a violation of the Fourth Amendment because you had knowingly turned those phone numbers over to the telephone company. And the telephone company, you knew that they used those in the routine course of business. And Miller is similar, only it's even more troubling because it's about bank records. And basically because banks are a party to the transaction, I write a check to you, but of course it gets cleared through the bank. So all of a sudden the court said that's the bank's business record, and I as a consumer, if law enforcement wants to access that, have no independent privacy interest to prevent that acquisition. All right, now Congress stepped in to fix both of these to more or less, less an extent in Smith, but a little bit better in Miller. But the important concept is that if something becomes a business record, even though it contains information about me, I have very little control over law enforcement access to it. And so as information about you moves out into the network, right, it moves off my PDA and off my desktop onto some little motes on the wall, right, I have much less control over law enforcement access to that. And also, because it's considered a business record, you can imagine the complexity of me saying that, well, the business can't disclose that to somebody else because it's mine. Okay. Tort law is also a little important, even older, right? This is going back, this is like, privacy common law. Intrusion upon seclusion, publication of embarrassing private facts, false light. These are kind of the celebrity torts, right? The tell-all. You see somebody talking about their spouse or their family and then getting sued. But I think when we're thinking about sensor networks and we're thinking about the kinds of information that could be collected, some of these actually might be interesting. We might see, some revival in these kinds of privacy torts. When we think about sensor networks, I think the most important area of law to think about is data protection, which is the European term. Here, we think about it as more fair information practice in the U.S. These are the principles. These principles are the basic of statutory protections here, worldwide, fairly consistent. And if you look at them, they're not... in the EU, there are some kind of flat-out prohibitions about collecting certain kinds of data that we consider sensitive. In the U.S., except for in the context of the government, which isn't supposed to collect information about our First Amendment, exercise of First Amendment freedoms, there's very little limitation on what people can collect. And what these rules, I like to think about them, think of them as kind of due process protections. And so it means that if you're going to collect data, you have to let me know you're going to collect data. If you're going to use it to make decisions about me, I have to have access to it. I have to be able to challenge it. That you have to collect data of a certain quality if you're going to make certain kinds of uses. You should only collect what you need. You should collect it with my consent. You should be transparent about it. There should be appropriate security. And you should be accountable for whatever it is you say you're going to do. These are all very nice rules. However, when we start thinking about sensor networks, they don't necessarily map very well. So I talked a little bit about the statutory protections earlier, the Miller and Smith cases, and the way in which Congress responded to them. These statutory protections, Title III and the Electronic Communications Privacy Act, are probably the most important statutory protections dealing with sensor networks, although, again, they're not necessarily all that responsive. Title III is restrictions on eavesdropping. The Electronic Communications Act, Privacy Act, ECPA, basically extended some of those Title III protections so that interceptions of email, right, again, became something that law enforcement were not allowed to engage in, private parties aren't allowed to engage in. And it set up a very complicated, decreasing set of protections for stored records, whether it's stored email or other kinds of stored records that are stored with things called remote computing services. And they're just things for you to know a little bit about. So if you look at privacy laws today, these are some of the kind of operating assumptions under them. Data collection is the exception, right? We have this very patchwork approach. They're based on notice and consent. I'm going to understand that you're collecting data. We have this distinction between public and private spaces. And as information moves away from you, as I mentioned, the privacy protections become much more porous, right? And there was at some level an assumption, right, that the personal would operate on either side, if you want to think about the internet, that the internet wouldn't be a place, right? There wouldn't actually be anything occurring on the internet. Everything would be occurring at the endpoints, much like the phone system. And that just isn't the case. I mean, people refer to cyberspace as a place, I think, for very good reason, in that people are actually storing their diaries in places outside their home, their date books, right? So this is it just doesn't map very well. there's a belief that there was a real big wall between the private sector and the government, and there's little regulation in our law about government acquisition of private data. And if you think about all of the hoopla over CAPS 2 or over the now terrorist information awareness, used to be total information awareness, right? And basically DHS saying, well, we're only acquiring data legally. And yes, they're only acquiring data legally because there's no rules that says that they can't acquire things, right, from the private sector. And part of the reason that there was very little focus on the private sector and very little focus on government acquisition is that the private sector wasn't in the position to collect the kinds of data that they can today. And when we think about sensor networks, I think the data collection possibilities just, loom enormously. Data collection engagement by a limited set of entities, pretty straightforward. And communications is ephemeral, and this distinction between content and everything else. I think those are other things that our law really enshrines that don't necessarily map very well here. So these are two quotes just about sensor networks, and I like them because they're relatively old, but also because they talk about disappearing, becoming invisible, and I think they really start to hint at the way in which the general framework that we have for thinking about privacy doesn't map very well. So we have, in sensor networks, data collection becomes the norm. We have an absence of cues that signal that data collection is occurring. We have this disappearance of private and public spaces. Sensing devices may actually be able to sense us even though we have moved from one space to another. Everyone becomes a potential data collector, right? And how do you map a law that require, all of a sudden I am the entity collecting the data, and how do we map our general kind of mainframe computer collection practices onto this? We have these new kinds of data. I don't even know what to call some of the data that we're talking about sensing. It's certainly not defined in any of our statutes, I can tell you that. And we have this increased ability to create knowledge out of data that used to be just, bits. It's just going to change, I think, tremendously. The ability to influence behavior and alter the environment, some of that being very positive, but some of it enabling the kinds of profiling without necessarily the same kinds of data collection, and creating some kind of very interesting feedback loops, right? It may fall outside of our privacy law, but actually the end result might be similar. And this always-on nature of sensor networks. So some of the big questions that I think I would leave you with, I talked earlier about the way in which technology can influence the scope of the Fourth Amendment. And as technologists, and you're thinking about developing new applications, and as business people pushing them out into the world, I think it's very difficult to be agnostic when you understand the relationship between legal interpretations of reasonable expectations and what's technically possible. Who should be responsible? When we're talking about sensor networks, and there, at least in some instances, anybody could walk in and kind of interact with the network and use the information, it's very difficult to think about how you protect privacy, right, whatever it is, when you don't know what the person who's coming into your environment knows, right? You don't know what other data they might have. How do we consider system design and policy issues in this multi-use technology? A lot of the technology that's being developed, this is very low-level technology. A lot of the privacy issues are quite contextual, and they require us to actually look at the technology within given environments. I think it's very difficult to do it at an abstract level. So I think some of the big questions for researchers: transparency and control. The whole goal is to be unobtrusive. Can we actually square those two things, or do we have to think about different ways to meet the same value proposition, the notion that individuals shouldn't kind of be surreptitiously watched? How do you evaluate the privacy risk when you don't know who's accessing the information, right? Very, very difficult question. Is there some kind of authentication system that happens, or are there limits on how the data can be combined with other sets of data? Do you design around the weaknesses of existing privacy law? I talked about the way in which the privacy protections kind of disappear as we move away from the individual. And what does that tell you about how you structure systems, and how long you retain data, those kinds of issues? And these 3 bullet points, the implications of these systems, right, for private actors with the access to information, just 2 little snippets. One is in the tobacco litigation around liability for the tobacco companies for smoking-related illnesses that the states were paying for. Massachusetts actually used a bunch of cost data that it had on its population because they have kind of a centralized database with all of the folks in Massachusetts' health information. It's redacted, it's not necessarily supposed to be personally identifiable, but we know that you can fairly easily recombine data. And they used it to make some statements about the costs of smoking to the state. And of course, the tobacco companies said, well, we want to be able to analyze the data and see if those are accurate, right? And so, you have this data, and all of a sudden somebody is trying to gain access to it. Most data is subpoenable. And not just in the context of privacy, but in the context of complaints about, some part of your system was faulty. What in this sensor node data should have told you that something was going wrong? I think there's lots of questions about these new collections of data, whether it's kind of copyright database questions or just kind of straight up, what kind of liability exposure is there in this collection of data, and how do you think about protecting it or limiting what you maintain? These kinds of issues are important. And as you're thinking about sensors, I think there's a need to think about the law. Are there areas where the law should be changed to enable some of the deployments that would be most socially useful? And how do you work with policymakers to make sure that there's kind of a proactive effort to design responsive laws rather than a reaction, like some of the RFID proposals we're seeing right now? And I'd be happy to take your questions.
Maybe while we're waiting for questions there, we can get Professor Lee to come down. Don't go away.
Yeah, I won't.
Here's a question. Jim, yes?
So suppose you wanted, there's a business or there's a researcher to engage in this. How does one start? Because it seems like there's a vast amount to learn. Would it be engaging with your explaining?
Sure, yeah. We've done some of the work that we're doing right now. I'll give you some examples. I had 2 SIM students. One's a PhD student, one's a master's student. And we basically did some research on a deployment of locator badges. It was a locator badge and an intercom system that was being deployed in a hospital setting. And we went in and talked with the nurses and to see how they reacted to it and what their concerns were. And we tried to map their concerns and figure out how the technology was kind of eating away at them, and what the goals of the system actually were. So doing some kind of evaluation. Right now, we've been working with the Berkeley Public Library. They're looking to implement RFID within the library context, and been working with them to look at, what do the technologies offer. Libraries have both state law that governs them, and they have a pretty strict Library of Bill of Rights that is very strong on privacy and free expression issues, and what are the potential threats the technology poses? How could they advance their goal, which is really dealing with stress-related injuries? So, we're very interested in looking at application-specific stuff, and then from there, trying to figure out, can we think of some new framework? I really think that kind of the Fair Information Practices framework doesn't work. So if we start getting a sense of what people's values are, right? There's a lot of literature on values, but I think it's very useful to look and give in specific contexts to get a better sense of what the values are, people's privacy values are in that setting, and try to build up from that to get a sense of how we might think about reconstructing some other framework that protects privacy values that's a little bit more in sync with sensor networks.
I know there's another question, but in the interest of time, I'm going to ask them to sort of take that
Sure.
with you offline. Do you think now would be a good time to tell folks about the sensors in these badges and the around the doors?
Would be a good time.
Okay, well,
I didn't get the waiver.
look inside. You didn't get the waiver. Thank you very much, Deirdre.